So thanks for coming today. As I've said, there's a one-page handout. It also came around with the email. I think I know most, if not everyone that's here, but it's best not to assume that. So my name is Elisa Arcioni. I'm an associate professor here at the Sydney Law School. Now, with apologies in advance for my pronunciation. Ninari Nalawangan Mari Bajari Gadi Nurada, which in the language of the Gadigal, here in the Sydney Basin, means we meet to talk together here on the beautiful country of the Gadi. So I recognise we are on Gadigal land and I acknowledge any First Nations peoples here today. As those of you who know me will know, I am not Indigenous. I am like just over half of the Australian population who were either born overseas or with one foreign-born parent. Now, my aim today is to explain some of the background of the Voice proposal that is the focus of the referendum at the end of this year, and to place it in the context of Australia's legal history and constitutional structures. I do so from my perspective as an expert in constitutional law, with a particular research interest in membership and exclusion under the Constitution. I've got some recent publications and works that relate to the Voice or to First Nations and the state, so just look at my staff profile for them. Now, today I hope to give you some background information to assist each of you in exercising an informed vote in the forthcoming referendum, but also to encourage you to learn more and thereby be in a position to counter misinformation when you see it and hear it, as you no doubt will as we get closer to the referendum itself. Because I'm sure you're all aware of the lack of civics and history literacy in the community, and in particular with respect to the Constitution, referenda, and the interaction of Australian law with respect to Aboriginal and Torres Strait Islander peoples since the British arrived in this place. And as those of us here who are legal academics or legal students, I'm sure you appreciate the weight and authority you hold when you speak about any matters related to the law, especially when you're not at work or university, when you're out talking with friends, family, neighbours, community members. So I think it's particularly important for all of us to be informed about this proposal so that when we do inevitably have discussions in informal settings, we know what we're talking about. But I'd also encourage you to go beyond those informal settings. And if you're interested in helping the community more generally understand this proposal, to become involved in processes of community legal education. I've been out talking in schools, community organisations, but I've also been talking to parts of our own university community. And there's a need, both within the university for staff and students, as well as outside, to become more informed. The government has said they will run a neutral civics campaign, but alongside that, and in the absence of that for now, I think we as legal educators and law students have a responsibility to assist the community to be ready to vote in this referendum. So to that end, if you're interested in doing so, please get in touch with me as we start to engage in those kinds of community education activities on campus as well as off campus. There's also a law and social justice project that some of you here may be involved with, and so Simon Rice would be the best contact person for that. So for today, I'm going to aim to talk for about 20-25 minutes and then open up to questions and discussion. The presentation part is being recorded for colleagues and others who can't make it today. The recording will not include the Q&A session afterwards, so I want everyone to feel free to ask questions and have an open discussion and for that not to be recorded. Okay, so let's get into it. Sometime from probably late October or November, we will have a referendum. And you know the mechanics of what that means, that all Australian electors will be asked to vote on whether or not to insert a new Section 129 into the Constitution, and that change will only occur if a majority of electors in a majority of states, as well as a majority voting nationally, all vote in favour of the change. The proposal is, as we know, to insert a voice to Parliament and government. Now, enshrining the voice would be an act of constitutional recognition of First Nations peoples. It's to be a representative body of First Nations, which will be given the function of making representations to the Parliament and executive government of the Commonwealth. That is, a body to provide a guaranteed process to get First Nations views to Parliament and government about things that affect First Nations peoples. So the first question that often arises is, where did this idea come from? Well, we can go back to the early days of the Australian colonies or federation, when First Nations groups asked, even at that point, for a say in political decisions made over them, given that the British had imposed their law on this country without the consent of First Nations peoples, and then set up laws that were discriminatory against those peoples. Now, in terms of the operation of British colonial law and then Australian law, I assume you're all familiar with the operation in fact of terra nullius, whereby the prior claims of possession, occupation, any form of ownership or control by First Nations peoples were, in a simplistic overview, ignored by the colonial authorities. While there was an early period whereby some colonial authorities chose not to intervene in disputes which involved only Aboriginal people, the operation of colonisation quickly led to an assertion of British law as the only law recognised and operative on the Australian landmass. Now, after the creation of the 6 British colonies, colonial law then recognised Aboriginal and then Torres Strait Islander people as having the same formal legal status as non-Indigenous people. But the rights and legal independence that usually go along with that status were denied to them. So stark examples include restrictions on political participation, as well as basic freedoms of movement, being free to choose whom to marry, whether and how to hold property and wages, and then the legal system which supported the stolen generations policy for 60 years, from about 1910 to about 1970, including the forcible removal of children on the basis of their Aboriginality. So in a sense, we have a straightforward legal history of extreme discrimination while holding the formal legal status of British subject or Australian citizen. But that legal history fails to make clear the destructive effects of the practical reality of the way in which colonisation occurred, which you can see in records of dispossession, frontier warfare, and other accounts, leading to intergenerational trauma and disadvantage. So that brief background is just to explain the impact of colonial and Australian law against which Aboriginal groups and leaders then rallied to seek a voice in the decisions made over them and about them. So to give an idea of that long history of calls for a voice to Parliament and government, I can identify a series of examples. We can start with colonial examples, including petitions, such as one by Tasmanian Aboriginal people to Queen Victoria regarding an agreement with Governor Arthur in 1846, or one by Wurundjeri elder William Barak regarding the Victorian Aboriginal Protection Bills of the 1880s. After Federation, we have examples including David Unaipon calling for autonomy, Frank Maynard calling for the abolition of the protection and control arrangements regarding Aboriginal affairs. Into the 1930s and 40s, there were multiple calls for specific representation in federal parliament, including by Yorta Yorta man William Cooper, Joe Anderson, known as King Burriga, and the Australia Aborigines League. Later examples arise in particular from the Yolngu in Arnhem Land, and you may have heard recently of the passing of Yunupingu, a key figure amongst a family of key figures involved in the creation of the Yedakala Bark Petition in 1963, and then the Burunga Statement in 1988 calling for treaty. Now, in the meantime, we did have the 1967 referendum, which removed some words from the Constitution. The races power was amended to remove the exclusion of Aboriginal people in the states from its scope, thereby granting the Commonwealth power to make laws with respect to them under the broadened races power. Section 127 was deleted to remove the exclusion of counting Aboriginal people from the census for a variety of constitutional calculations. But neither of those constitutional changes affected the structural issues being railed against since colonisation. And ironically, those changes meant that Aboriginal and Torres Strait Islander peoples were then completely absent from the text of the Constitution. Of course, we can also mention, in terms of a legal development, the Mabo No. 2 decision of 1992, which marked the moment when the High Court recognised that the doctrine of terra nullius was based on a historical fallacy and sought to reach a compromise of retaining dominant British sovereignty while recognising some native title rights, if they were not inconsistent with Australian property law granted under Australian law. So the Mabo decision was significant, but it continued to maintain that only the Australian law would be given authority and no account of First Nations law. So coming back to the Constitution, more recently, we had federal politicians entering the fray, suggesting constitutional recognition of First Nations. Prime Minister John Howard proposed a symbolic recognition in the preamble in 1999 that would mention Aboriginal and Torres Strait Islanders, the nation's first peoples. That proposal was defeated at referendum across the country, and the idea of a symbolic recognition with no legal force was rejected by First Nations peoples. What followed over the next 15 years was a series of inquiries and proposals by legal experts, but without any agreement by Parliament and no consensus on what form recognition would take. So that brings us to the Uluru Statement from the Heart. After politicians had suggested constitutional recognition and a series of prime ministers had talked about it, but without a clear agreement on what form it would take, we had another series of proposals from the expert panel on the recognition of Aboriginal and Torres Strait Islander peoples, established in 2010, reporting in 2012, and then a joint select parliamentary committee in 2014. But then in 2015, a group of First Nations leaders met with the Prime Minister Malcolm Turnbull and opposition leader Bill Shorten and issued the Kirribilli Statement, asking for clarity from them as to the parameters of what they would support in relation to constitutional recognition and urging engagement with First Nations people. Essentially, it was a call to allow First Nations to come up with a proposal, given the lack of political leadership and will within the Parliament and federal government over decades. So in December of that year, the Prime Minister Malcolm Turnbull announced the establishment of the Referendum Council that would oversee a deliberative process designed and led by First Nations peoples. And what followed was a series of 13 dialogues across the country with First Nations peoples, resulting in the Uluru Statement. So the Uluru Statement of 2017 was the result of a First Nations-led process to identify what First Nations wanted from constitutional recognition, as the latest in what I hope is clear to be a very long history of calls for a say over the law and policy that applies to, and so often disadvantages, Aboriginal and Torres Strait Islander peoples. So the answer to what First Nations people want is in the Uluru Statement, the call for voice, treaty and truth. But before coming to those elements, let me briefly outline the dialogue process. So the dialogues were a deliberative process across the country, run across 2016 and 2017, run by First Nations peoples for First Nations peoples, bringing together the largest and most extensive consultation process that we have seen in our nation's history. They were conducted in regions across the country with Secretariat support from the Australian Institute of Aboriginal and Torres Strait Islander Studies, IATSIS. The purpose of each of the dialogues was to get a robust representative sample of First Nations views about recognition and reform. A local land council or other representative body hosted each dialogue in partnership with IATSIS. The participants were organised through a formula of 60% from traditional owner groups, 20% from local community organisations, and 20% local community members, as well as members of the stolen generations. That formula was to capture cultural authority, local needs, and seek to avoid domination by individual groups or individuals themselves. So each dialogue was capped at 100 people and lasted for 3 days. First, there was a civic session, then plenary discussions, breakout groups, and then the participants of each dialogue settled and agreed on a written record of their meeting. The only non-Indigenous people were advisors for the civics component at the beginning, and they did not engage in the dialogue discussions themselves. Now, it's the representatives of those dialogues across the country that then met at Uluru, at the National First Nations Constitutional Convention. The delegates drafted the Uluru Statement to reflect the consensus position of the dialogues, with the outcome being the call for voice, treaty and truth. So now to those elements. Voice is the voice proposal we see coming to referendum, and I'll come back to that. Treaty is a coming together of First Nations peoples and the Australian state, a process of agreement making. And you'll see reference to the term makarata, which is a Yolngu term that can be translated as a process of coming together after a struggle. Truth is the telling of the history of our country so we can understand the reality of what has happened since the British arrived in the late 1700s. So if you've not yet read it, I'd encourage you read the statement. It's short, it's available in multiple languages. We also have a video that's on repeat in the law school that you might have seen, which sets out the Uluru Statement with comment by staff and students from across the university, but highlighting the law school. And there's a link to that in the handout that's both here physically and sent through the email invitation. But now let me focus in on the voice. The voice proposal is the only part of the Uluru Statement that needs constitutional change. And there are two main reasons for it being placed in the Constitution. First, it has to be entrenched so that it is a statement of constitutional recognition of First Nations peoples. That's just a definitional point. Second, it's so that the existence of the body is guaranteed. So that unlike other representative bodies or structures, you could think of, for example, ATSIC, the voice can't then be disbanded if the parliament or government don't like what they see or hear. Constitutional enshrinement would also then confer upon the voice a legitimacy and democratic force through the process of enshrinement, requiring the passage of a bill through the parliament and then acceptance by a majority of the Australian electors. So now to the details of the provisions. The wording has been approved by the Cabinet in negotiation with an Indigenous working group and is now before the Parliament. We will see the parliamentary debate and a parliamentary inquiry, which is currently on foot, before the Parliament votes on the proposal so that it can be put to the people. And if I can just note now that I've drafted a very short submission for that inquiry, and it's still open for signature by any colleagues, professional and academic, within the law school. So please email me by the end of today if you haven't already got in touch, as we need to submit it by tomorrow. So now to the words of the proposal, and they're set out on the handout that you might have picked up. It starts with a preambular statement of recognition of Aboriginal and Torres Strait Islander peoples as the First Nations of Australia. This would make it clear that the voice is a recognition of First Nations peoples, because following the referendum in 1967, there is no mention of First Nations peoples within the text of the Constitution and no explicit reckoning with the historical reality of First Nations being here from before colonisation. Then there is the key statement that there shall be a body called the Aboriginal and Torres Strait Islander Voice. Then a statement as to its key function, that the Aboriginal and Torres Strait Islander Voice may make representations to the Parliament and the Executive Government of the Commonwealth on matters relating to Aboriginal and Torres Strait Islander peoples. This captures the core of what the voice is about, and to answer the call made in the Uluru Statement for structural reform to address political powerlessness. Then the final part is a conferral of legislative power on the Parliament so that, subject to the Constitution, the Parliament can make laws with respect to matters relating to the Aboriginal and Torres Strait Islander voice, including its composition, functions, powers, and procedures. Now I'm going to explain how the proposal for the voice as drafted is consistent with Australian constitutional structures. The first point to make is that the design is similar to what we see in the design of other institutions. That is, the Constitution typically sets down the basic details, the existence of an institution, its basic role, and then the details are left for the Parliament itself. That's what we have in general terms for the establishment of the Parliament. That's what we have for the judiciary, including the High Court. And it's not only a common design feature in our Constitution, but it's the way many constitutions across the world are set up, that one guarantees the core components in the text of the Constitution and leaves the details for ongoing negotiation and change over time by the Parliament. This approach is particularly appropriate for the voice because it allows for First Nations peoples to negotiate with the Parliament about how they are to be represented by the voice and for that to change as is necessary. Because we know the identity and cultural traditions of First Nations across Australia are complex and diverse, and their composition and laws are not static. First Nations peoples are heterogeneous, with distinct internal rules for membership and structures for representation. So acknowledging this diversity leads to the conclusion that the best way to ensure that First Nations are able to participate in determining the membership of the voice is to have the rules of its membership within legislation so that the drafting can be informed by and in consultation with First Nations people. We also have design principles, which are also set out on the handout, that have been approved by Cabinet regarding the voice that would also guide that legislation in due course. In addition, we have existing examples and practices with respect to legislation as to how to control the impact of consultative processes in terms of how it interacts with the making of legislation and regulations how it impacts on the exercise of executive power and decision-making, which can in turn be applied to representations of the voice. That is, Parliament can decide from time to time what, if any, legal impact the representations will have. And I'm particularly grateful to our colleague Andrew Edgar for helping me understand that component of the design, as I'm no expert in administrative law. And I direct your attention to our joint AusPub Law blog titled The Voice and the Executive for more detail there, as well as our joint submission to the parliamentary inquiry. But all the credit in terms of the substance goes to Andrew for his expertise. I also want to note that the views expressed in our post and in our submission are consistent with those expressed by the expert testimony on the first day of the parliamentary hearing on the 14th of April. So I'd suggest you could also look at the testimony given by former High Court judges and constitutional law experts with respect to the interaction between the representations of the voice and executive and parliamentary power. Okay, so in having the constitutional provision indicate an outline of the main function of the voice and then a conferral of legislative power to address the details, the design and structure of the voice fits within our constitutional system, whereby it's the Parliament that has the main role in implementing the reform and determining the details. It therefore fits within our political system, whereby the people elect a Parliament and the Parliament exercises its legislative power to confer functions on the executive and set up the rules whereby that power is to be exercised and controlled. But of course, we also have the judiciary as part of our system, and it acts as a backstop to ensure that the Parliament operates within its power. So it's going to be neither possible nor desirable for legislation regarding the voice to be non-justiciable in the sense of it being immune from consideration by the High Court. But we can expect the court to step in only rarely and to strike down legislation only if it contravenes the existence of a voice or its capacity to make representations. All of the other elements will be in the purview of the power of the Parliament. So if you're still with me, let's turn to now think about how the voice is supposed to work and what is it supposed to do. A constitutional First Nations voice is intended to be both symbolic and practical. It would be a statement of who we are as a modern nation, recognising the place of First Nations people as part of our polity and recognising their distinct history and cultural connection to lands and waters. The Constitution does indicate who we are as a nation, who belongs, and how power is exercised. So our Constitution is also symbolic and practical. Changing the Constitution to guarantee a First Nations voice would be an important statement that we have moved on from the historical exclusion of Aboriginal and Torres Strait Islander peoples. But the voice is designed not to be an empty bureaucratic structure or a mere rhetorical symbol that won't achieve real change. It's intended to be the vehicle for practical action to address Indigenous disadvantage. The practical effect of the voice would be to guarantee a facility for First Nations views to be received by the Parliament and government. Because as we know, decisions about First Nations are so often made without them or their input. And our system of parliamentary democracy is majoritarian. So given the numerical minority status of First Nations peoples, they can't have proper representation through that system. Individual Aboriginal and Torres Strait Islander members of Parliament will continue to represent their local electorate or state or territory, and of course the views of their political party. But there would be an institution, the Voice, to speak for all First Nations peoples without the party political or electoral limitations imposed on members of Parliament. So the Parliament would be established as an institution entrenched in our political system of government. It's been a body designed to be representative of First Nations, able to give representations, expert views to the Parliament and government in terms of what impact decisions, laws and policies would have on First Nations peoples. If you think of any of the recent or historic decisions, policies, laws, government practices that have had a detrimental impact on First Nations peoples, or if you consider the areas of disadvantage that are highlighted in the Closing the Gap data, then you can get an indication of what kinds of areas of law and policy the Voice would make representations upon. Now, will the government always listen and do what the Voice asks or suggests? Maybe not. And in fact, the Voice cannot force the government or the Parliament to do what they ask. The outcome will be a matter of political decisions for the government and Parliament of the day. But what will change is that First Nations voices will have a guaranteed place in the political discussions, a guaranteed structure through which to inform the government about issues affecting First Nations. Because this is part of a long game, not a short political fix. The Voice is aimed at acclimatising Australian public institutions to listening to First Nations, with the aim of incremental change over time to make better decisions. So when the Parliament passes laws, they would do so fully aware of the impact the laws may have on First Nations. When the government is making decisions and devising policies, they would do so informed of what it will mean and how it may affect First Nations. We, the Australian people, more broadly, will be able to see how the government and Parliament navigates this information and form our own judgment. And I think a better informed government and Parliament would be better for all of us. But the Voice also has a broader purpose in keeping with the calls made in the Uluru Statement, and that is to set up the conditions for treaty and truth-telling. The First Nations groups that came together at Uluru understood the political and legal realities of the Australian system. In order to have an equitable negotiation for a treaty, there is a need for a structure that can bring First Nations together in a way recognised by the Australian state and which has a guaranteed place in the Australian system. So the Voice is needed for the two to come together. That then links with what we hear about sovereignty in some of the commentary. Some raise concerns that the Voice would cede First Nations sovereignty, but the answer is it can't. First Nations sovereignty is drawn from their connection to lands and waters, their laws and their internal authority. As the Uluru Statement states itself, First Nations sovereignty coexists with the sovereignty of the Crown. So we live in a reality where there are multiple laws and legal systems operating in the same physical space that we call Australia. But the reality of colonisation means that the Australian legal system will only apply Australian law. The Voice would neither cede First Nations sovereignty, nor would it cede the sovereignty of the Crown. Now, before we go to questions and discussion, let me return to the Uluru Statement, because it is the source of this proposal for a voice. The Uluru Statement is described as an invitation by First Nations peoples to the Australian people to walk together in a movement for a better future. The Voice proposal is a First Nation proposal arising from that statement, as written by First Nations peoples. It is not a politician's or government's proposal. The only way for the Voice to be brought into reality is for the Australian electors, 97% of whom are not Indigenous, to accept that invitation. Hence the need for the government and Parliament to get involved at the first stage, because the Parliament must pass the proposal before we, the electors, can have our say. So the Voice proposal overall is a modest but potentially influential reform. It is the latest in a very long history of calls by First Nations peoples for a voice in the law and policy which affects them. It was developed out of a representative and consultative process, bringing together First Nations groups from across the country. And as I've indicated, it is structured consistently with the way in which we set up institutions in our Constitution. We have existing approaches and structures and legal principles which can help determine the legal impact of the representations of the Voice, and as is appropriate and orthodox in our system, it will be for the Parliament from time to determine the legal operation and ongoing impact of the Voice. So hopefully what I've said has confirmed some of the things you may already have known. Hopefully I've given you a little more information in terms of the background and the context to understand the Voice, so that you're possibly more informed than you were before you came here today to help exercise your vote in the upcoming referendum. But I also hope that you will share some of the things you've learned and that we'll discuss when this recording is over with others, so that we can continue the very slow and incremental process of education across the community.